The landmark Americans with Disabilities Act is federal legislation. It was enacted by Congress in 1990, and it prohibits discrimination. It ensures equal opportunity in several areas. And the 5 areas are employment, public services, including state and local government services, public accommodations, which are such as the restaurants, and commercial facilities, stores, telecommunications, and miscellaneous. So these are where you can find the all of the sections of the ADA. So Title II covers public services. That's the right to access public services. And includes all services, programs, and activities regardless of federal funding. Remember, it just has to be state or local funding, and regardless of the number of employees. So it can apply to even a place where there are only 5 employees. Think of it, and it applies to public bus service, government meetings, public schools, universities, recreation facilities, state parks. And it prohibits people from being excluded from participating based on the disability, prohibits people with disabilities being denied services, programs, activities, not being afforded equal opportunity, being provided different benefits or services, and it prohibits limiting any right, privilege, advantage, or opportunity provided to others. Title III is interesting because it does apply to private schools. It mandates the accessibility of all services, even those privately owned. It requires all new places of accommodation, all new places, because some places can be grandfathered in. If you go to an old restaurant, they may have a restroom on the 2nd floor with no access by elevator or only by stairs, so that's grandfathered in. Examples of public accommodations include public gathering places, restaurants, bars, movie theaters, places of lodging, hotels, motor inns, motels, inns, retail stores, and social service centers. So under the ADA, private schools are required to make, again, non-secular private schools, not religious private schools. Private schools are required to make reasonable accommodations and provide auxiliary aids and services to ensure that students with disabilities are not excluded, are not denied services, are not segregated, and are not treated differently than other students. Title III defines discrimination in part as the failure to take such steps as may be necessary to ensure that no individual with a disability is excluded, denied services. So Title III does not impose requirements for appropriate individualized education for students with disabilities. A covered private school must comply only with, and when I say covered private school, again, non-secular, it must comply with the more general anti-discrimination requirements. So again, who's protected under the ADA? A person with a disability, which is defined as a physical or mental impairment that substantially limits major life functions and has a record or history of an impairment or is regarded as having an impairment. And the ADA was amended in 2008, and so we call it the ADA, AA, which is the Americans with Disabilities Amendment Act. It expanded the definition of disability from very narrow construction to a much more broader interpretation. The changes apply to both the ADA and the Rehabilitation Act, and it expanded what are the major life activities, which we discussed before. Reading, concentration, thinking, and communicating was very limited before that. And there are a couple of cases that you have in your materials, and that was the genesis of expanding the ADA, because the purpose of the amendments was, according to Congress, to restore the intent and protections of the ADA. Congress had found that the expectation of the ADA, which was to eliminate discrimination against individuals with disability, wasn't being met, that there was still prejudice, there's still antiquated attitudes, and societal and institutional barriers remained. And so there are 2 cases in your materials, Sutton v. United Airlines and Toyota Motor Manufacturing against Williams. Those were employment cases, but those actually in those cases, people with disabilities, they basically were discriminated against, and so Congress said, no, you really do have to expand this two other, you have to expand the definition of it as we intended. So the difference between the ADA and the 504 is both prohibit discrimination. 504 was passed in 1973. ADA was modeled after it in 1990. 504 is limited to entities receiving federal funds. The AD extends to private institutions and workplaces. It even applies to, we're just a two-attorney office. It applies to our office if someone came in and required, for instance, an interpreter, a client, we would have to provide an interpreter for that client. The ADA applies to entities that receive federal funds and entities that receive state monies and to privately owned institutions and establishments.